This is clearly a face-saver for both parties.
Hello, welcome to The View from 22 from SpectatorTV. I'm Cindy Yu, I'm the Spectator's assistant editor. Now, overnight we've had breaking news that a surprise deal has been struck between Julian Assange and the US government, which sees him freed this morning. To join me now to discuss this some more is Professor Andrew Tettenborn, who is a legal expert at the University of Swansea. Now, Andrew, you've written about this for Coffee House just this morning. Tell us, what is it that you think about this case?
Right. Well, obviously, we're very glad about Julian Assange. Finally, after I think it's about 15 years, he's free and probably heading to Australia either today or tomorrow. And obviously, I think we're glad that finally a journalist who's been admittedly rather rude about the United States has escaped being sent to a maximum security United States prison. What I'm still worried about is what this says about press freedom in this country. Because if you look at the background, Julian Assange had absolutely nothing to do with the United States. He was Australian, he was operating from England. He wrote largely in The Guardian, though in one or two other European publications. What he wrote didn't break any English law, because our Official Secrets Act covers our official secrets. It doesn't cover somebody else's official secrets. He then finds himself the subject of an extradition request from the United States on the basis that he got his information from Chelsea Manning, who had broken United States law in the United States in order to get the information. And the United States demanded his extradition. Now, the worrying thing about that is that essentially we're now in the business of enforcing the US official secrets legislation. And that's something that worries me enormously.
Well, let's just pause here, because I think, I totally understand what you're saying in terms of this deal. Let's just look at this deal first of all, because it doesn't actually, it kind of concedes the principle of the matter to the US government, doesn't it? Because I think Julian Assange is admitting guilt, but actually being allowed to have a different sort of sentence, which he's already given at Belmarsh in the UK. So it's not that the US has said, oh, you didn't do anything wrong at all. The underlying principle there is still being conceded.
You're absolutely right as a matter of law. This is clearly a face-saver for both parties. There were undoubtedly hawks in the US who wanted to make an example of Julian Assange. What the US has actually done has agreed we'll find a fudge under which he's sent to the US, because the US officially are punishing him. They're saying, right, you've got 5 years for a specimen charge, but oh, wait a moment, you've done 5 years in Belmarsh, and we'll count that towards your sentence. One gets the impression, actually, that the State Department is weary of this, and undoubtedly the Home Office is weary of it, and they were absolutely delighted that they reached this arrangement. But the problem is, of course, that other journalists may not have the high profile of Julian Assange, and they're still very much under threat. Because you've got to remember something else about the request to extradite Julian Assange. If we get a request of this sort, we have no choice but to give way to it. Now, until 2003, our extradition law actually had a very good emergency brake, in that the Home Secretary had the right in the end to put his foot down and say, sorry, this simply isn't going to happen. This was got rid of in 2003. Extradition is now very much a rubber stamping exercise, provided that they get the paperwork right. There is no discretion anywhere in anyone not to send him back. The only protection is human rights. But of course, the trouble is that the free speech protection of the European Convention is, first of all, pretty niggardly anyway. Secondly, good luck if you try and invoke it against a charge of espionage.
So it's a new Labour legacy then, 2003 you mentioned.
It was. Right. What happened was this. Under the old extradition law, actually it was rather sound, there was a list of extradition crimes which didn't include espionage. There was also an exception to extradition in respect of political offences, which would have included espionage, and there was the emergency brake available to the Home Secretary. Now, the history was that when they introduced the European arrest warrant within the EU, they said, oh, get rid of all that, we all trust each other. Therefore, extradition should be a rubber stamping exercise. And in 2003, the government took the opportunity to say, oh, well, let's show that, we're going to treat all countries the same, and let's extend the rubber stamping exercise actually to most countries in the world, including the United States.
Yeah.
And that's another difficulty actually here, because, okay, we're all in NATO together. You could say betraying US secrets is a harm to everybody. It's a harm to us as much as to the US. The problem is that this also covers lots of other countries. Suppose that the complainant hadn't been the US, but Brazil, Israel, South Africa, any number of other countries.
And these are countries that we do have extradition treaties with.
Exactly the same rules apply to, say, Korea or Israel as apply to the United States.
Tomorrow, India came to us and said, we have the Sikh activists in the UK. They have been threatening our national security. We need him back now.
Precisely. If they can say this Sikh activist has suborned someone in India to go into one of our computers and take state secrets, they could have made exactly the same request as the United States did, and the result would have been exactly the same. And that's what's also extraordinarily worrying, because it means that journalists now have an enormous threat lying over them. If they want to be rude about a particular regime, all that regime has to do in order to silence them is say, well, actually, can we please have extradition? These guys have clearly obtained information in breach of our espionage laws through some cat's paw in our own capital, and therefore you have to extradite them. The only protection being human rights, which, as I say, as far as I can see, is something of a broken reed.
Yes, absolutely. And so your concern, and I totally share it, is not just for journalists in the US, for example, but it's for journalists in the UK who are being put under these similar kind of demands from a country with which we have extradition treaties with, and the Home Secretary can't even do much about it.
There is, of course, a further debating point you can make. If the tables had been turned and we had wanted someone back from Uncle Sam on the basis that they were a journalist with the New York Times and they had suborned someone here to break the Official Secrets Act, would the US have sent them back? Would they? Hell. They'd have been protected by the First Amendment, and in any case, the US undoubtedly would have found a way of not doing so. So it's a very one-sided relationship, this.
How has this come to pass? I mean, Andrew, excuse me, because I'm not a legal expert, but this seems like a drastic change from what it was like before. Was it just slipped under?
It was an attempt to suck up to the United States. We wanted to keep the special relationship humming along. There was no way the US could reciprocate because it would be unconstitutional, be contrary to the First Amendment, possibly also various other constitutional provisions like due process. But nevertheless, Tony Blair was prepared to go along to the US request. A number of people pointed out at the time that this gave the impression that basically when the US said jump, we jumped, and weren't particularly concerned but with the rights of our citizens. This is now very much coming home to roost.
Well, he probably wanted to give that message to the US when you say jump, we jump.
Of course, yes, he did, but he didn't want to give that message to people in this country. And there were actually a number of commentators here who pointed out that this was a remarkably one-sided arrangement.
And going back to the Assange case then, Andrew, as you write this morning, this is a fudge to the situation. This is not the end of the principle here, even if Assange himself now has his freedom back, we hope. What about if Keir Starmer gets elected in the next, within 2 weeks, as a former chief prosecutor, how do you feel about how likely it is for this situation to change under a man who is formerly a chief prosecutor himself?
I'm afraid I think it's a case of snowflakes in hell. I'll tell you why. Because Labour will be desperate to demonstrate that it's tough on law and order. And one simple way of doing it is to say, well, the law will run its course. We see no reason to do anything about it. The only way in which you might persuade a Labour government to do something about it would be to say, well, wait a moment, what if you have an authoritarian government in somewhere like Brazil or Peru, and you have a left-wing journalist in The Guardian? Do you really want this country to be forced to send that person off to Lima to face charges in Peru? That's the only thing I think which could remotely persuade a Labour Home Secretary, or for that matter, Keir Starmer, that it's time we did something about it.
And Andrew, I know you're based in the UK, but I wonder, this is something that I'm curious about. What does this whole episode say about the state of the American legal system and the moral legitimacy there is in that? In the sense that, supporters of Julian Assange would say that he whistle-blew on really necessary things, taking them out into the public eye, things, potential human rights abuses that the American military committed in Iraq and Afghanistan, and he has been persecuted for years. What does this say about the state of the American legal system that, it seems like it's just something that's inconvenienced the American government rather than an illegal act per se, when especially as well Chelsea Manning, the soldier who gave those materials, has been pardoned herself?
Well, that I must admit does leave a slightly sour taste. Having said that, I'm not sure that you can use this that much as a means of attacking the American government. If Julian Assange had gone to the United States and been prosecuted, I think it's pretty clear he could certainly have invoked the First Amendment. How far the First Amendment would have applied is a different matter, but there is actually quite strong protection for free speech in the United States. It's much stronger than it is here. But I certainly agree that there would have been something very odd about Julian Assange languishing in some supermax while Chelsea Manning flits free wherever they care to go.
And finally, Andrew, then, what about the future for Julian Assange? He is going to Australia very, very shortly, but the details of the deal are not out yet. Could, if Trump was voted in later this year, we've seen some Republicans already hand-wringing about Julian Assange being let off, as they say. Could Trump reverse something like this?
I think the chance... I don't know Australian extradition law. Sorry, I have to be pompous there and say I'm not qualified to advise on foreign law. My feeling is that the State Department, I think, would be very unhappy to reopen this can of worms. I think probably the United States, even if Trump gets in, will say, sorry, that one's got away. What you'll have is Julian Assange ending up as a sort of John Pilger figure, continuing to write very acerbic articles about what's going on in the world. I suspect probably he may be forgotten within 2 or 3 years.
Okay, Andrew Tettenborn, thank you so much for joining Spectator TV.